My name is Richard Fincher, and I'm a mediator and arbitrator of labor disputes and graduate of the ILR School. My objective today is to share the details of a series of labor arbitration cases concerning medical marijuana in the workplace. As the arbitrator, the issue presented to me is simply, was there just cause for an employer to discipline a worker who tests positive for THC, works in a safety-sensitive job, yet has a bona fide medical marijuana card from their state? There are three background concepts you need to understand. The first is, what's a safety-sensitive job? And it's typically a job that involves dangerous equipment or can put people at risk, such as airline pilots, fork truck drivers, underground miners, train engineers, or school bus drivers. The second concept is, what is the federal law concerning the obligation of employers to test employees for drug use? And typically under the Department of Transportation or the Mine Safety Act, employers do have a duty to conduct certain drug testing of their workers. And the third concept is that many states have passed implementing legislation that is very pro-employer in upholding the employer rights to a drug-free workplace for safety-sensitive jobs. And this implementing legislation, of course, differs from each state. So now let's move on to the actual cases that I've seen. And the employer argument is very straightforward. The company implemented a drug and alcohol policy requiring fitness for duty. The policy identifies safety-sensitive jobs. By policy, the worker must disclose his drug use to the health and safety department, including medications. There's annual safety training, and the company has retained a medical resource officer and a testing firm for the collection of specimens. So what happened that triggered the grievance? Well, the company drug tested a worker and the result was positive for THC. There's no chain of custody dispute. The employee typically admits knowing of the policy to disclose, yet did not do so. And unlike alcohol testing, the employer contends that there's no accepted cutoff score for impairment due to marijuana. So the employer contends that the discharge is not excessive, does not need to be progressive, but the discharge should be upheld. Now, there are two medical issues that come from these set of facts. The first is, what's impairment? And is there a drug test, in fact, for determining marijuana impairment? Impairment is generally defined as a diminishment of cognitive skills, whether spatial or judgment. And is there a current urine test with a cutoff score for determining medical marijuana impairment? Typically not. So what is the union's perspective on all this? Well, the union argues that, of course, the discipline is an overreaction, is excessive. In fact, the grievant was an excellent worker. He had no prior discipline. He was never impaired. There was no accident or damage. That there was no incident prompting for-cause testing by a supervisor. Sometimes the union will claim the state law preempts company policy. Certainly, the grievant denies that he ever digested marijuana on the job site or the morning before coming to work. And again, the union's perspective is that a discharge for a first offense of testing positive for THC is excessive and should be reversed. So in conclusion, these cases are treated like any other just cause matter, namely three things. One, was there a company policy defining expectations? And was there clear evidence of a worker violating the policy? Number two, were there any due process violations, such as Weingarten rights? And number three, is the discipline consistent with prior cases or inconsistent or excessive? I hope this summary has been helpful for your understanding of how arbitrators view medical marijuana disputes in the workplace. Thanks.